To all the distinguished guests, esteemed colleagues, respected faculty members, students, and participants, and most importantly, the wonderful team of Legal into Legal World who have collaborated with our university, T.S. Mishra University, to organize such an enthusiastic seminar. I feel deeply honored to be here today at this national seminar to speak on the topic New Criminal Laws for a New Era Need, Focus, and Long Term Vision. My heartfelt gratitude goes to the organizers at the at for organizing this much needed dialogue on a subject that lies at the heart of our democracy and injustice system. The criminal justice system is often considered the backbone of any society, responsible for maintaining order, protecting rights, and ensuring justice. In India, the foundation of our criminal laws dates back to the colonial era, primarily with the Indian Penal Code, the Criminal Procedure Code, and the Indian Evidence Act, all of which were drafted in the 19th century. While these laws served as the legal framework for over 150 years, they increasingly became inadequate in addressing the needs of a modern, diverse, and rapidly evolving society. This seminar offers an excellent platform to critically analyze the journey from the old criminal laws to the new ones and to assess whether they fulfill the expectations of an evolving India. We must explore the need for such reforms, the focus they aim to bring, and the long term vision they aspire to achieve for our country. Thought behind reforming criminal laws. Historical background. The roots of India's criminal law lie in the colonial era when the British administration introduced the Indian Penal Code 1860, the Code Criminal Procedure Code 1861, and Indian Evidence 1872. While these laws were undoubtedly comprehensive for their time, they were created with the primarily goal of maintaining colonial control over a subjected population. Justice, as envisioned in these laws, often took a back seat to governance, order, and suppression of dissent. After independence, although India retained and adapted these laws, their colonial framework continued to influence the justice system. Over time, its colonial framework became apparent and these laws were outdated, rigid, and ill suited to the aspirants and complexities of a modern democratic and diverse society. Issues like criminalization, procedural insufficiencies, and inadequate victim protections called for significant changes. The reforms we are now witnessing are the result of decades of advocacy by legal scholars, precautionary practitioners, and policymakers to bring the criminal justice system in line with the needs of contemporary India, dividing force behind driving force behind reforms. Several pressing issues and developments made the case for reforming India's criminal laws, changing societal needs. Over the past century, Indian society has undergone profound transformations from the rise of nuclear families to increasing urbanization and changing role of women in society. These shifts have exposed gaps in older laws. For example, laws addressing sexual violence, domestic abuse, and crimes against children were inadequate to handle the growing awareness and complexity of these issues. Societal values have also evolved. The emphasis is now on justice that is not only punitive but also rehabilitative and restorative. Victim centric laws and priorities restitution, counseling, and dignity were largely missing from the colonial era framework. Technological advancement. The 21st century has brought with a wave of technological developments that have radically changed the way crimes are committed and investigated. Cybercrime, including online fraud, hacking, phishing, and identity theft, was not even conceivable during the drafting of the IPC. Similarly, issues like data privacy, digital harassment, and artificial intelligence based crimes require specialized legal framework and provisions. The growing reliance on digital evidence in criminal trials has underscored the need to update procedures related to evidence collection, authentication, and admissibility. Globalization and international obligation. India's increasing integration into the global economy has brought with it new challenges, such as transnational organization crime, human trafficking, and financial crime involving multiple jurisdictions. As a signatory to various international treaties and conventions, India is obliged to bring its laws in alignment with global standards on issues like terrorism, environmental crimes, and human rights. These new criminal laws aim to balance these international commitments with India's unique social and cultural context, judicial overload, and delays. One of the most visible challenges in the India's criminal justice system is the massive backlog of cases, procedural insufficiencies in CRPC, such as redundant stages of inquiry or outdated method of trial, have contributed to delays that can span decades. The reforms aim to streamline these procedures, making them simpler and more time efficient with provisions for fast track courts and alternative dispute resolution mechanisms, public trust and accountability. Over the years, the public's trust in criminal justice system has been eroded by corruption, delays, and perception of basis. The new laws seek to rebuild this trust by introducing stricter accountability mechanism for law enforcement agencies and judicial officers. Expectations from law reforms. The modernization of India's criminal justice system through the recent replacement of colonial era laws brings forth several critical expectations for meaningful reform. These reforms must bridge historical gaps while creating a more efficient and inequitable system for contemporary society. A primary expectation is the shift from purely punitive approach to a more balanced reformative justice system. This includes introducing alternatives to imprisonment, such as community service, especially for the first time offenders and minor crimes. The justice system needs to focus on rehabilitation and uh, reintegration of offenders while maintaining deterrence for serious crimes. Thus, this aligns with modern criminological understanding and international best practices. Institutional strengthening forms another crucial expectations with the need to address the 21% nationwide policy vacancy and enhance forensic infrastructure. The reforms must provide for regular training, capacity building of law enforcement personnel, and modernization and investigation techniques. This includes integrating technology for better evidence collection and case management. The high proportion of under trials, about 77% of prisoners, highlights the expectation for speeder justice delivery. Reforms should strengthen bail provisions, especially for first time offenders, while introducing effective mechanisms for faster case disposal. This includes enhanced plea bargaining options and alternative dispute resolution mechanism for appropriate cases. Protection of rights and ensuring fair trials remain fundamental expectations. The reforms must codify important Supreme Court and High Court directions for uniform implementation nationwide, particularly regarding arrest procedures and bail guidelines. Witness protection mechanisms need strengthening, and vulnerable groups require special consideration in legal procedures. Alignment with the international standards in another key expectation. The current minimum age of criminal responsibility, 7 years, needs revision to match global norms and United Nations recommendations of 12 plus years. Modern strengthening guidelines similar to those in UK and US should be introduced to ensure consistency and fairness in punishments while considering local context. The reforms are expected to enhance public accessibility to justice. This includes simplifying legal language, updating absolute realizations, and making procedures more understandable for common citizens. Regular public feedback mechanisms and transparency in processes should be integral to the system. Technological intervention in a criminal a critical expectation with provisions for binding digital evidence, electronic filing systems, and virtual court proceedings where appropriate. The reforms should address emerging challenges like cybercrime while ensuring privacy protections. Resource allocation and infrastructure development from vital expectation. This includes adequate budgeting for court infrastructure, modern equipments for law enforcement, and comprehensive training program. Regular monitoring and review mechanism should be established to assess the effectiveness of reforms and make necessary adjustments. The resource These expectations reflect the need for a comprehensive overhaul of the criminal justice system to create a modern, efficient, and just legal framework that serves all citizens effectively while maintaining the balance between law enforcement and individual rights. Key features of new criminal laws. The implementation of three new criminal laws, Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita and Bharatiya Sakshya Adhiniyam marks a significant overhaul of India's criminal justice system, replacing colonial era legislation from 1816, 1973, and 1872, respectively. These reforms comprehensively address modern challenges while introducing progressive elements into the legal framework. The Bharatiya Nyaya Sanhita introduces community services as a new form of punishment, emphasizing reformation for minor offense alongside in traditional punishment like death penalty, like imprisonment, rigorous or simple imprisonment, forfeiture of property, and fines. It explicitly addresses contemporary challenges by incorporating as specific provisions for mob lynching and organized crime. The law also dedicates a separate chapter to crimes against women and children, reflecting increased attention to vulnerable groups. Additionally, it updates legal terminology, replacing terms like minor with child and including transgender under gender definitions. The Bharatiya Nyaya Suraksha Sanhita brings significant procedural reforms with a citizen-centric approach. It establishes fixed timelines for various procedures and limits court adjustment to streamlining the justice process. The law embraces technological advancement by mandating forensic investigation for offenses punishable by 7 years or more imprisonment and allowing electronic service of summons. It also creates uniformity in court structure by streamlining judicial designations, abolishing metropolitan magistrate and assistant session judge provisions positions for consistency across the country. The Bharatiya Sakshya Adhiniyam modernizes evidence law as an adjective law, expanding the scope of admissible evidence to include electronic and digital records. It recognizes these as it recognizes these as primary evidence, departing from their previous classification as secondary evidence. The law broadens the definitions of documents to include matter expressed or described on any substance by any means, adapting to modern forms of communication and record keeping. It also expands secondary evidence to include oral and written admissions, enhancing the scope of admissible evidence, fulfillment of expectation, a critical assessment. The implementation of new criminal laws since July 1, 2024 represents a significant attempt to modernize India's criminal justice system. Let's assess how these reforms have addressed identified gaps and their early impact. Progress made in addressing identified gaps. The reforms have made substantial progress in several key areas. The introduction of community service as an alternative punishment marks a shift towards reformative justice, particularly for minor offences. These addresses the long-standing criticism of the system being purely punitive. The mandatory forensic investigation requirement for serious offences demonstrates commitment to scientific investigation methods, though infrastructure challenges remain. The law have successfully modernized several aspects: digital integration through electronic summons and evidence handling, streamlined court procedures with fixed timelines, updated legal terminology reflecting contemporary needs, specific provisions for modern crimes like mob lynching and organized crime, enhanced focus on crimes against vulnerable groups, recognition of electronic records as primary evidence. However, some critical gaps remain. The age of criminal responsibility remains at 7 years, limited provisions for plea bargaining, institutional bottlenecks not fully addressed, overlap between special laws and new provisions. Ground level impact. The initial months of implementation have revealed both positive developments and challenges. Developments. Regular assessment, regular digital integration has begun showing results in reducing procedural delays. Fixed timelines for procedures are helping streamline case management. The unified court structure is creating consistency in judicial processes. Enhanced provisions for digital evidence are facilitating modern investigation methods. Community service options are providing alternative to imprisonment for minor offences. Implementation challenges. Infrastructure gaps, particularly in forensic facilities, affecting mandatory forensic investigation requirements. Training needs for law enforcement in new procedures and technological aspects. Adaptation period required for courts and legal practitioners to new provisions. Resource allocation for implementing new technological requirement. Coordination between different agencies under the new framework. The real impact on key issues like the high under trial population and case pendency will take time to assess, while the framework for improvement exists in the new laws. Their effectiveness will depend largely on the proper implementation and resource allocation. The reforms demonstrate significant progress in modernizing the legal framework, but their success will ultimately depend on addressing implementation challenges and providing inadequate resources. Continued monitoring and adjustment of implementation strategies will be crucial for achieving the intended objectiveness of, of these comprehensive reforms. These early months have shown promise in several areas while highlighting the need for sustained effort in others. As the system adapts of these changes, regular assessment and necessary adjustments will be key to ensuring the reforms achieve their intended goals to create a more efficient, accessible, and just legal system. What are the changes will still needed in criminal law in India? Comprehensive cybercrime provisions. Introduce new sections addressing modern cyber offenses such as cyberbullying, online stacking, phishing, email hacking, and social media crimes as recognized by the National Cybercrime Reporting Portal of the Government of India. Data protection offenses. Amend the definition of property under the Bharatiya Nyaya Sanhita to explicitly include data, making data theft a punishable offense. Virtual world crimes. Introduce new sections to account for offenses committed in virtual environments, including metaverses and through AR. All related offenses draft provisions to address crimes involving artificial intelligence, such as deep fakes and AI generated content misuse, which are currently not covered under the BNS. Technology neutral language. Revise the language throughout the BNS to include terms like cyber, virtual, digital, electronic, and data to ensure applicability to both physical and digital crimes. Clear definitions. Provide precise definitions for terms such as economic security and economic offenses in section 111 of the BNS to prevent misuse and ensure consistent application. Safeguard against misuse. Introduce checks and balance in sections related to terrorism and organized crime, particularly regarding the discretionary power given to superintendents of police evoking terrorism changes under the BNS, charges under the BNS. Gender neutrality. Revise section 63, rape of BNS to make the gender neutral, considering the non reenactment of Section 377 of the Indian Penal Code, addressing emerging financial crimes. Introduce new sections to address sophisticated technological frauds such as cross-border cyber heists and cryptocurrency related offenses. Balancing political dissent. Amend Section 172 of subsection 2 of BNS to attempting to commit suicide to compel or restrain applying lawful power to ensure protection of legitimate forms of political agitation and protest. Regular updates. Introduce a provision mandating periodic review and updates of the BNS to keep pace with rapidly evolving technology and societal changes. Addressing bestiality. Reintroduce provisions criminalizing bestiality, which were present in the Indian Penal Code but omitted in the BNS. Cybercrime hub provisions. Introduce sections to address the phenomena of cybercrime hubs to enable effective law enforcement in such areas. Specific takeaways for law students. As the future custodian of justice, law students play a vital role in shaping the success of these criminal law reforms. Here are some key takeaways for students in attendance day today. opportunity to study new provisions. With the introduction of new criminal laws, students have the unique opportunity to engage with fresh legal principles and precedents. Focus on understanding the rationale behind changes, such as victim centric justice, simplified procedures, and technology enabled evidence collection. Comparative analysis with international legal system can provide valuable insights into best practices. Developing research and advocacy students must delve into researching the new laws, identifying their strengths, and critically analyzing political loopholes are areas for improvement. Punishing research papers, Publishing research papers, participating in moot courts, and attending seminars on these reforms will enhance their understanding and credibility as legal professionals. Importance of interdisciplinary knowledge. Modern criminal law reforms touch on terminology, sociology, and economics, among other fields. For instance, understanding cybercrime or financial fraud requires basic knowledge of digital systems and financial markets. Law students must adapt the acquiring in interdisciplinary knowledge, which will enable them to handle complex cases in the future. Practical training and adaptation. Hands-on exposure of new procedures such as handling digital evidence, navigating fast-track courts, and leveraging alternative dispute resolution mechanisms will be crucial. Internship with legal practitioners, judicial officers, or even law enforcement agencies can provide invaluable practical insights. Upholding ethical standards. As the legal system evolves, ethical practices remains a cornerstones of the profession. Students must pledge to uphold the highest standards of integrity, ensuring that the reforms translate into meaningful justice for society. Active contribution to legal reforms. Beyond academics, law students can participate in public consultation, policy discussions, and advocacy efforts to improve the implementation of these laws. Engaging with NGOs, legal aid programs, and public interest litigation can help amply the voices of marginalized communities, ensuring that the reforms are inclusive. Vision for the future. The reformation of criminal laws is not just about addressing the shortcomings of the past, it is about envisaging a brighter future where justice to accessible, equitable, and efficient for all citizens. Long-term goals. The, the ultimate aim of these reforms is to create a justice system that is robust, adaptive, and resilient. This involves addressing systematic issues such as delayed trials, under reporting of crimes, and corruption. By simplifying legal procedures and emphasizing fairness, the reforms strive to ensure that justice is not delayed, denied, or derailed. Role of stakeholders. The success of these reforms depends on the collaboration of all stakeholders, including lawmakers, the judiciary, law enforcement, legal professionals, and civil society. Policymakers must continue to refine the laws based on public feedback, and judicial interpretation. Legal professionals and academics must educate the public and practitioners about the changes to ensure effective implementation. Continuous evaluation of laws. Laws can't be remain stable in a dynamic world. Regular reviews and attendments should be institutionalized to ensure that the legal system evolves alongside society. The technological advancement, social shifts, and global challenges will necessitate further changes in the legal framework, fostering public trust in the system. Reforms should ultimately restore faith in the judicial system by ensuring transparency, accountability, and fairness. A justice system that prioritizes the needs of the common man, empowers victims, and holds attention accountable is the key to achieving this vision. Role of youth and legal fraternity and youth professionals will be at forefront of implementing and shaping the changes. Their enthusiasm, fresh perspectives, and commitment to justice will determine the success of these reforms. Encouraging active participation in governance, public policy, and legal disclosure will empower them to create a better future for the legal system. Conclusion. As I conclude my discussion today on India's transformative journey in criminal law reform, I find us standing at a crucial juncture in our nation's legal history. The replacement of colonial era laws with the Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita, and Bharatiya Sakshya Adhiniyam represents not just a change in legal framework, but a fundamental shift in now we envision justice in modern India. These reforms embody our collective aspirations for a justice system that is both efficient and equitable, utilizing modern technology while preserving human dignity and introduction of community service as an alternative punishment, mandatory forensic investigation for serious crimes, and recognition of digital evidence reflects India's commitment to building a justice system that both progressive and pragmatic. However, I must emphasize that legal reforms is an ongoing journey, not a destination. The challenges I have identified from cybercrime provisions to AI related offenses remind me that our legal framework must continue to evolve. The success of these reforms will depend not just on the letter of the law, but on the spirit and which they implement them, the resources we allocate, and dedication of all stakeholders in the justice system. To the law students present here today, I want to emphasize that you are not just witness to the historic transformation, but its future custodians. Your role in shaping, interpreting, and implementing these laws will be crucial in realizing their full potential. As you step into your professional roles, I urge you to remember them that the true measure of these reforms will be their ability to deliver justice to the common citizen effectively, transparently, and equitably. I move forward with optimism, knowledge that while challenges remain, the foundation has been laid for a criminal justice system that reflects the values and aspirations of modern India. A system that balances the needs of law enforcement with individual rights, embraces technological advancement while preserving human judgments, and above all, ensures that justice is not just done, but is seen to be done. The path ahead requires sustained commitment, continuous learning, and unwavering dedication to the principles of justice. I believe we can build a legal system that not only serves the present generation but sets a strong foundation for generations to come. As these reforms are, are implemented, I remain mindful that our ultimate goal is not just to modernize our laws, but to strengthen the very fabric of justice that holds our democratic society together. Thanks for listening me.